Why are patent searches important? Patent searches can help you determine if your invention is novel and non-obvious, which are essential requirements for obtaining a patent. They can also help you make sure you're not infringing on someone else's rights or know the state of the art before you start developing an invention. If you have a great idea and think you're ready to move forward with sales or applying for a patent, are you really? Have you checked whether someone else already has rights to an identical or similar invention? Do you truly know all existing technology in that field? Many inventors and business owners skip comprehensive patent searches, assuming their idea must be unique simply because they haven't seen it before. Unfortunately, this oversight can lead to costly legal battles, wasted investments, and immense disappointment. Conducting patent searches early in the invention process protects you by clarifying potential conflicts and ensuring that your time, energy, and resources are directed toward viable opportunities, not wasted on something that will cause trouble for you. Think of patent searches as a vital early step that will help prevent disastrous and costly surprises. In this episode, I'll go over types of patent searches and why they're important, how patent searches are done, evaluating patent search results, what happens after the searching is done, and working with patent professionals to use patent searches as a valuable step in securing your intellectual property. What are patent searches, and why are they important? There are 5 main types of patent search, and here's what they're called, what their purpose is, and when they're used. A novelty or patentability search involves reviewing existing patents, patent applications, and publicly available literature to assess whether an invention is new and non-obvious compared to prior art. This is essential to know before filing a patent application because applications for inventions that aren't novel or non-obvious will be rejected. A freedom to operate patent search is a comprehensive examination of active patents and patent applications within jurisdictions where you intend to market your invention. Its purpose is to identify existing patents and potential patents that your invention might infringe upon, which is important to know before launching your product or service. A validity or invalidity patent search is a detailed analysis of patents, prior publications, and materials available before the patent's filing date. It reviews those to determine if they're enforceable or can be challenged. This kind of search is most often used in litigation or licensing negotiations. A state-of-the-art patent search provides a snapshot of the latest developments, technologies, and trends in a specific field. It's ideal for guiding research and development efforts, identifying technology gaps, and informing initial innovation strategy. A landscape patent search is similar to a state-of-the-art patent search, but in much greater depth and detail. It offers a comprehensive overview of patent activity within a particular technology or industry. It's extensive, historical, and forward-looking, and it includes competitors' patents, patent clusters, filing trends, and emerging opportunities or threats. This kind of search is valuable for strategic planning, competitive intelligence, investment decisions, and identifying potential collaboration or licensing opportunities. Too many inventors shy away from patent searches because they think patent searches are too expensive. And the thing is, it's much less expensive to do a patent search than to deal with the consequences of not doing one and finding out the hard way that you should have done one. Some other inventors get confused and intimidated by not knowing what kind of patent search they need. How do you do a patent search? And can you do one without a patent attorney? Some patent searching can be done on your own and should be, and some should be left to the professionals. Here's the difference. First, I'll tell you a secret. It's not a bad idea to start with a DIY search. You might not hear that from many patent attorneys because, after all, doing searches for clients is part of how we keep the lights on. But sometimes our expertise, and more importantly, client money, is wasted on a search that a little DIY digging could have handled. Here's some great resources available for a DIY search. The U.S. Patent and Trademark Office, or USPTO, provides free access to its vast patent database, allowing you to search by keyword, inventor, or specific patent classifications. It is limited to United States patents and applications only. Google Patents is another excellent tool, offering intuitive search features and global coverage. Additionally, the World Intellectual Property Organization, WIPO, also offers international patent search capabilities. That's important because international patents can stop a U.S. application from being granted, even without any corresponding U.S. rights. so it's wise to look globally. General Googling and searching on sites like Amazon are also great tools. If you do a quick DIY search and you find inventions that are clearly identical or similar to yours, you know you have a problem without spending any money. At that point, it's back to the drawing board. Once you've made changes that you're pretty sure make your invention different from the ones you found, or if you didn't find anything obviously problematic in your searching, it's time to have a professional search done to be sure. Although DIY searches can be useful, professional patent searchers and attorneys bring specialized expertise and deeper analytical insight. They can help identify subtle distinctions between inventions and know which ones matter and which don't. They can also help you decide which kind of search or combination of searches will suit your unique situation best. Here's something to keep in mind about patent searches, whether you're doing a preliminary DIY search or having a patent attorney do one for you. In the US, patent applications usually aren't published until 18 months after they've been filed, and provisional patent applications are never published. That means patent attorneys can't access those unpublished applications, and that means no patent search outside of the USPTO can be 100% accurate. If any attorney tells you otherwise, run quickly. However, given the vast amount of patents, applications, and other sources of information about inventions that are available, patent searches are still significantly important tools. By using both DIY and professional patent searches, understanding how to do them effectively, you're safeguarding your invention, minimizing risks, and positioning your idea for future success. What do patent search results mean? And once the thorough patent searches are done, what happens next? Results from patent searches are powerful knowledge if they're analyzed properly. Evaluating the search results carefully is crucial. If potential problems emerge, it's essential to address the severity of each issue. Not every potential problem is equally problematic. Minor issues may be able to be resolved through small adjustments to your invention. However, if significant issues arise, such as finding a patent that closely mirrors your invention, you might face a more serious decision. A patent attorney can provide clarity on the legal landscape, guide you through risk assessment, and suggest strategies to help you safely navigate forward. Your decision to stay the course, pivot your plans, or pause entirely will be better informed and strategically sound. Why should you work with a patent attorney? Partnering with patent attorneys for patent searches provides peace of mind. Now say that 10 times fast. Patent attorneys not only conduct in-depth searches, but also interpret complex and nuanced legal results, offering guidance tailored specifically to your situation. Now, by law, patent agents aren't allowed to give you legal advice about search results. Only patent attorneys are allowed to do that. Here's an example of what can happen if you don't work with a patent attorney to have a patent search done. I had some clients who were indeed experts in their field and who were 100% certain there was nothing else in the world like their invention. So they didn't want to spend the money on a patentability search before filing a patent application. Now, despite being experts in their field and sure that they were current on everything in it, they were wrong. Now we're working on arguing against refusals of their patent application because there are, in fact, existing patents the examiner thinks are too similar. Now, it could be worse. The examiner could have found patents that my client turned out to be infringing. But if the clients had had me do a patentability search before filing their patent application, they could have stopped spending time and money on pursuing a patent application, perhaps doomed to fail, or risking being accused of infringement by selling the invention if the patent examiner had found one that looked like they were infringing it, and instead revised their invention to truly be innovative and non-infringing before seeking a patent. Or they could have simply proceeded without seeking a patent if the search results indicated risking infringement likely wasn't an issue. Skipping a patent search is a gamble, period. The consequences of being wrong about whether your invention is unique and not infringing on someone else's patent rights can be awful and expensive. Now, I won't force the client to have me do a patent search, but if they don't have me do one, I hope the odds are ever in their favor, and they might end up having to spend more money down the road than they would have on an initial patent search. By dedicating the time and resources upfront to have the necessary patent searches done and analyzed, you're investing in the health and longevity of your business. If you'd like help with a patent, let's talk. You can use my contact form on my website, or book a consultation online at kingpatentlaw.com or by calling my office at 312-596-2222 or 217-714-8558. Please check out my other podcast episodes on YouTube, Spotify, etc., and the other posts and pages on my website for more information on patents and other intellectual property and business law issues.